disputes between the parties, my view is that the issue as formulated by Learned Claimants Counsel adequately covers the field of dispute in the suit. As such, the court hereby adopts same in determining the suit. In adopting the issue, I should state that I have carefully considered and taken due benefit of the totality of the arguments canvassed in the said written final submission and oral submissions. I shall make specific reference to the arguments as I deem necessary in the course of this judgment. Now, it is considered pertinent to begin a consideration of the issues at stake by adverting to the fact that the claimant has sought declaratory reliefs in the suit, but the implication being that the burden for him to prove the allegation leveled against the defendants exceeds the regular burden provided in Section 131 and 132 of the Evidence Act 2011. The claimant is to succeed on the viability and strength of the case made out on both his pleadings and evidence. See the authorities of Dumes Nigeria Limited versus Nkogba, Ogolo versus Ogolo, Ndayako versus Dantoro, and Olabanchi versus Omokweno, citation also applied. Proceeding on the footing of this legal principle, therefore, the task the court is to undertake now is to examine the evidence on record as adduced by the claimant and the law applicable thereto in order to determine whether or not such evidence has satisfied the requirements of proof imposed by the provisions of Section 131 and 132 of the Evidence Act as amended to substantiate the claimant's claim as endorsed. The story as told by the claimant is that Emmanuel Babayaro was the chairman of Kaduna United Football Club when he was engaged by the defendants to serve as technical advisor to the club for the 2012-2013 and 2013-2014 seasons of the Nigerian National League. The claimants testified that no written contracts was given to him for his engagement, but the terms of his contracts was for a sign-on fee of 3 million naira and a monthly salary of 350,000 naira. The claimants testified that he started his duties without being paid. Excuse me. Without being paid the sign-on fee, and at the commencement of the season, he approached Honorable Sabo Babayaro, who promised to facilitate the payment before the end of the 2012-2013 season. That at the beginning of the 2013-2014 season, he again approached Sabo Babayaro to remind him of his unpaid sign-on fee, and that while waiting for his response, the board of the first defendant was reshuffled. The claimants testified further that he raised the issue of his unpaid sign-on fee at the first meeting of the board of the first defendant, where one Alhaji Hussein Zubeiru Biningweri, the then Commissioner of Sports, admitted that the claimant was engaged on a sign-on fee of 3 million naira and a monthly salary of 350,000 naira. The claimant alleged that the said sign-on fee and his salary for 9 months was not paid until his contract was terminated on the 25th of April 2014. According to the claimant, he made a complaint to the Nigerian Football Federation, the regulatory agency of League of Management Company of Nigeria, and the said letter of complaint was forwarded to the Players Status Arbitration Committee of Nigeria Football Federation, and that after several invitations to the defendants to make appearance, the Players Status Arbitration Committee ordered the defendants to pay the sum of 6,050,000 naira, being the sign-on fee and the arrears of salary. The testimony of the claimant is further that a letter was written to the secretary of the first defendant, notifying the defendants of the decision to pay the claimant the said sum on or before the 30th of June 2015. But when the defendants refused to comply with the order, another letter was written to the secretary, Kaduna Football United Club, to remind him of the payment, and when the defendants still refused to pay the claimant, a sanction was awarded to the first defendant. The following documents were tendered in further support of the claimant's case. 1. Claimant's letter of complaints addressed to the Secretary, Nigerian Football Federation, dated the 26th of February 2015 as Exhibit C1. 2. Letter stating the decision of the Nigerian Football Federation Players Statehood Arbitration Committee, dated the 11th of June 2015 as Exhibit C2. 3. Letter of reminder addressed to the Secretary, Nigerian Football Federation, dated the 22nd of October 2015 as Exhibit C3. 4. Letter of the enforcement of the decision of the Nigerian Football Federation Players Statehood Arbitration Committee, dated the 22nd of October 2015 as Exhibit C4. And 5. Claimant statement of accounts with Unity Bank PLC as Exhibit C5. A former member of the Board of Trustees of Kaduna United Football Club, CW2, confirmed in his testimony that the claimant was engaged as a technical advisor for the 2012, 2013, and 2013 and 2014 seasons. CW3, MH Sabo Babayaru, is a former chairman of Kaduna United Football Club. In his testimony, he confirmed that the claimant is entitled to his sign-on fee and salary as a technical advisor engaged by the club for the 2 seasons being claimed. While answering questions under cross-examination, the witnesses further testified that they were unaware if the claimant had a formal letter of appointment, but they maintained that they had knowledge that he served as technical advisor for the club and therefore entitled to his claims. I had also examined the testimony of one Yusuf Joshua, the sole witness fielded by the defendants, wherein he denied the entirety of the claimant's claim. According to DW1, the claimant was engaged as technical advisor by the first defendant between the year 2005 to 2007, that his contract was not renewed after it was terminated in 2007, and that his entitlement had been paid during the period of contracts. DW1 denied that the claimant was engaged by the first defendant between 2012 to 2014, that the board of the first defendant was dissolved in 2014, and that the defendants have never engaged any person to serve in any capacity in the first defendant without a formal contract. The defendant also denied that a meeting was held to discuss the claimant's entitlement and that the first defendant was sanctioned or suspended by the Nigerian Football Federation in relation to this agreement. DW1 maintained that the claimant was not terminated on 25th of April 2014 as he was never engaged as claimed. Now, it is settled that a claimant has the duty to lead evidence first, as the burden of proof to any particular fact lies on that person who wishes the court to believe in its existence, unless it is provided by any law that the proof of that fact shall lie on any particular person. However, the burden may in the course of a case be shifted from one side to another. See Section 131, 133, and 136 of the Evidence Act 2011. These provisions of the Evidence Act have been considered by the courts in a plethora of authorities. Sionovo versus Mba, Ntuama versus Akpeime, Nzemba versus Ibeneme, and another citation also applied. From the above authorities and the plethora of cases on burden of proof, it is clear that in order to discover where the burden of proof lies in the civil case, the court has a duty to peruse the entire pleadings of both parties. It is also the consensus of the case authorities that in civil cases, the burden of proof initially lies on the claimant. In other words, in civil cases, the claimant has the initial burden to lead evidence to prove his assertion, but the burden of proof is not static. Once the claimant establishes as a prima facie case, the burden of leading evidence in rebuttal shifts to the defendant and vice versa. I should also remark that the case put forward by the claimant is substantially documentary evidence. In that circumstance, the focus of the court is directed principally are the documents tendered by the claimant as the yardstick to assess the oral evidence adduced by the claimant's witness. This course is in consonance with the established legal proposition that documentary evidence, being the best evidence, is the yardstick or anchor by which to assess the veracity or credibility of oral testimony, and that extrinsic evidence cannot be admitted to contradict, add, or vary the provisions contained in a document. See also Section 128, Sub 1 of the Evidence Act 2011 on the issue. See also Skybank PLC versus Akinpelu and Ndubueze versus Bauer, citation supplied. Now, the crux of the claimant's case borders on his claim that he was engaged by the first defendant as technical advisor for the 2012-2013 and 2013-2014 seasons. The claimant had alleged that there was no written agreement for his services, but stated that the defendant agreed to pay the sign-on fee and salary. As correctly submitted by the claimant's counsel, the law requires that the claimant plead sufficient facts and lead credible evidence to establish his claims. The claimant relied on Exhibit C1, C2, C3, and C4 to prove that he was engaged by the first defendant. Exhibit C1 is the claimant's letter of complaint written to the General Secretary, Nigerian Football Federation, Abuja, and same was stamped as received on the 2nd of March, 2015. By the exhibit, the claimant based on the terms of contracts for the period of engagement as technical advisor to the club demanded for the payment of 6,050,000 naira only. The sum was calculated less the sum of 100,000 he had obtained as loan. Exhibit C2, C3, and C4 are the certified true copies of the correspondences between the Nigerian Football Federation, the Commissioner of Sports, Kaduna State, and the Secretary, Kaduna United Football Club. Exhibit C2 conveyed the decision of the NFF Player Status Arbitration Committee that the outstanding claims for services rendered the club must be paid to the claimant on or before the 30th of June 2015. Exhibit C3 was a reminder for the payment of the claimant's entitlement, whilst Exhibit C4 is a sanction meted to Kaduna United for its refusal to pay the claimant as instructed and conveyed by NFF. While answering questions on the cross-examination by the defendant's counsel, CW3, a subpoenaed witness, admitted that the claimant served as technical advisor of the first defendant between 2012 to 2015, when he was the chairman of the first defendant, and that there was no time the board of the first defendant disapproved the services of the claimant. The law is settled. The contracts need not necessarily be in writing, as the conduct of the parties may create contractual obligations. This is so because a contract may be expressed or implied. When there is no written agreement, contracts can be taken to be implied by the conduct of the parties themselves. See the cases of Shina Security Company Limited versus Afropac Nigeria Limited. See also the cases of Olange versus Afro Construction Nigeria Limited, and the case of B Stabilili and Co Limited versus Olabisi, cited by the learned claimant's counsel. As the weight of the evidence given by the claimants during trial varied or pumperdated, so did the evidential burden shift to the defendants to disprove the facts as stated in Exhibit C2, C3, and C4. While on the cross-examination, DW1 testified that he was unaware of the services of the claimant for the said period and that he was unaware of the documents because he had left the club at that period. The evidential burden clearly shifted to the defendants to disprove on a balance of probability these facts as stated in the exhibit. The defendants failed to discharge the burden that shifted to them. The above lapses makes Exhibit C2 to C4 have value, and therefore the claimant's claims can be hoisted upon it, and are so hold. In the final analysis, I hereby resolve the issues set down for determination in favor of the claimant. The judgment of this court is that the case of the claimant is substantially meritorious on the evidence laid on the record, and same hereby succeeds. Accordingly, it is hereby ordered as follows. 1. A declaration that the claimant is entitled to be paid a sign-on fee of 3 million naira only, having been signed on as technical advisor of Kaduna United Football Club for 2012, 2013, and 2013-2014 league seasons of the Nigerian National League. 2. A declaration that the claimant is entitled to be paid the sum of 3,050,000 naira only, being areas of salary covering the period between June 2013 to April 2014, which was not paid to him. 3. An order of this honorable court mandating the defendants to pay the claimant the total sum of 6,050,000 naira only, being the total of the sign-on fees and arrears of salaries due to him. 4. The sum of 500,000 naira only, being cost of this action. 5. The defendant shall pay the said sum in 3 above within 1 month, and thereafter at the rate of 10% per annum from the date of this judgment until same is finally liquidated. This is the judgment of the court.
As the court pleases, my lord.
My lord, we thank my lord for the well-considered judgment. May God continue to strengthen my lord. My
Amen.
lord,
Thank you.
my lord, may I add, my colleague Ferdinand Ikuru just joined the proceedings.
Who?
Ferdinand Ikuru just joined the proceedings, my lord.
Okay, I'll record him as together. I'd already recorded both of you on the face of the judgment that you handled the case.
As the court pleases.
As counsel for the claimants. Thank you.
Yes,
Thank you. Yes.
Yes, my lord, we are also equally most grateful for the well-considered judgment, and we abide by the orders of the court. We are most grateful.
Yes, I hope it's a new season in Kaduna State, and that this is the era of abiding with judgments.
However, my lord, yes, as the court pleases, my lord, I will still forward we'll obtain the judgment and forward it to the AG. If he agreed, then
that's why you have a right of appeal. It's not. I'm just reminding you of the fact that this is the era of you know what it is. So don't let us overstretch it. Thank you, sir.
As a company.
Thank you. Have a wonderful day, sirs. Thank you. Thank you so much. Thank you.
Thank you.
So can I have the next case, please?
Case number 1, NICS/PD/44/2019 between Rosenda Mabate, Villanueva, and General Metal Products Limited. I'll say my parents.
Parties, this is the case for adoption.
Yes, my lord.
Are parties in court? Parties absent?
Parties absent.
Parties absent. Appearances, please.
Barrister Sapera, please, you can go ahead.
Respectfully, my lord.
Yes.
My name is Levi Shapera.
Yes.
My lord, I appear for the defendant.
We do not have a representation for the claimant.
My lord, I called him. He said he's having network issues.
Okay, so we'll record it as long as we is served with the hearing notice. No legal representation for the claimants. Yes, Mr. Shapiro.
Yes, my lord, the matter comes up today for adoption of final written addresses.
Yes. Yes.
My lord, we filed our final written address.
It was deemed filed on the 25th of October.
2023, my lord.
It was deemed filed on
And
25th
upon the
of
receipt
October.
of the 2023.
Yes, thank you.
Hello, man. My lord, we also filed our reply.
Yes.
On the same 25th October 2023. We adopt the two written addresses as our own address.
Yes.
And urge my lord to dismiss the claimant's claim and grant our counterclaim.
Thank you. So we will deem the claimant's address adopted because we have a notice that he has network issues. So his own address will be deemed adopted.
As the court pleases.
As the case is adjourned to the 3rd of April, let's check again.
As the court pleases. My lord, we miss you so much, but the Lord knows better.
I didn't hear that.
My lord, I said we miss you in Kaduna so much, but the Lord knows better.
It doesn't take more than 3 hours to come over to Abuja to visit, sir.
My lord will be coming,
Very well, thank you. But, case is adjourned to the 3rd of April, 2024 for judgment.
As the court pleases.
I said 2024. Did I say 2023? I said 2024. Sorry. Thank you. Thank you. Yes, the courts will rise. Thank you very much. Have a great day, guys.
And you too.